Supreme Court of the United States. Syllabus. Haaland, Secretary of the Interior, et al. V. Brackeen et al. Certiorari, to the United States Court of Appeals for the Fifth Circuit. Number 21-376. Argued November 9, 2022, decided June 15, 2023. This case arises from three separate child custody proceedings governed by the Indian Child Welfare Act, ICWA, a federal statute that aims to keep Indian children connected to Indian families. ICWA governs state court adoption and foster care proceedings involving Indian children. Among other things, the Act requires placement of an Indian child according to the Act's hierarchical preferences unless the state court finds good cause to depart from them. 25 U.S.C. Sections 1915 A.B. Under those preferences, Indian families or institutions from any tribe, not just the tribe to which the child has a tie, outrank unrelated non-Indians or non-Indian institutions. Further, the child's tribe may pass a resolution altering the prioritization order. Section 1915C. The preferences of the Indian child or her parent generally cannot trump those set by statute or tribal resolution. In involuntary proceedings, the Act mandates that the Indian child's parent or custodian and tribe be given notice of any custody proceedings, as well as the right to intervene. Sections 1912, ABC Section 1912D, requires a party seeking to terminate parental rights, or to remove an Indian child from an unsafe environment, to satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent breakup of the Indian family. And a court cannot order relief unless the party demonstrates by a heightened burden of proof and expert testimony that the child is likely to suffer serious emotional or physical damage if the parent or Indian custodian retains custody. Sections 1912 D.E. Even for voluntary proceedings, a biological parent who gives up an Indian child cannot necessarily choose the child's foster or adoptive parents. The child's tribe has a right to intervene at any point in a proceeding to place a child in foster care or terminate parental rights, as well as a right to collaterally attack the state court's custody decree. Sections 1911C-1914. The tribe thus can sometimes enforce ICWA's placement preferences against the wishes of one or both biological parents, even after the child is living with a new family. Finally, the states must keep certain records related to child placement see Section 1915E and transmit to the Secretary of the Interior all final adoption decrees and other specified information see Section 1951A. Petitioners, a birth mother, foster and adoptive parents, and the state of Texas, filed this suit in federal court against the United States and other federal parties. Several Indian tribes intervened to defend the law alongside the federal parties. Petitioners challenged ICWA as unconstitutional on multiple grounds. They asserted that Congress lacks authority to enact ICWA and that several of ICWA's requirements violate the anti-commandeering principle of the 10th Amendment. They argued that ICWA employs racial classifications that unlawfully hinder non-Indian families from fostering or adopting Indian children. And they challenged Section 1915C, the provision that allows tribes to alter the prioritization order on the ground that it violates the non-delegation doctrine. The district court granted petitioners' motion for summary judgment on their constitutional claims, and the banc Fifth Circuit affirmed in part and reversed in part. The Fifth Circuit concluded that ICWA does not exceed Congress's legislative power, that Section 1915C does not violate the non-delegation doctrine, and that some of ICWA's placement preferences satisfy the guarantee of equal protection. The Fifth Circuit was evenly divided as to whether ICWA's other preferences, those prioritizing other Indian families and Indian foster homes over non-Indian families, unconstitutionally discriminate on the basis of race, and thus affirmed the district court's ruling that these preferences are unconstitutional. As to petitioners' 10th Amendment arguments, the Fifth Circuit held that Section 1912D's active efforts requirement Section 1912E's and Section 1912F's expert witness requirements and Section 1915E's recordkeeping requirement unconstitutionally commandeer the states. And because it divided evenly with respect to other challenged provisions Section 1912, A's Notice Requirement Section 1915, A, and Section 1915B's Placement Preferences, and Section 1951, A's Recordkeeping Requirement. The Fifth Circuit affirmed the district courts, holding that these requirements violate the 10th Amendment. Held. Syllabus Section 1. The court declines to disturb the Fifth Circuit's conclusion that ICWA is consistent with Congress's Article I authority. Syllabus Section 1A. The court has characterized Congress's power to legislate with respect to the Indian tribes as plenary and exclusive, United States v. Lara, 2004, superseding both tribal and state authority, Santa Clara Pueblo v. Martinez, 1978. The court has traced that power to multiple sources. First, the Indian Commerce Clause authorizes Congress to regulate commerce with the Indian tribes, U.S. Constitution Article 1 Section 8 Clause 3, and the court has interpreted the Indian Commerce Clause to reach not only trade, but also certain Indian affairs. Cotton Petroleum Corporation v. New Mexico 1989. The Treaty Clause provides a second source of power. The treaty power does not literally authorize Congress to act legislatively since it is housed in Article 2, but treaties made pursuant to that power can authorize Congress to deal with matters with which otherwise Congress could not deal. Lara 2004. Also, principles inherent in the Constitution's structure may empower Congress to act in the field of Indian affairs. See Morton v. Mankery 1974. Finally, the trust relationship between the United States and the Indian people informs the exercise of legislative power. United States v. Mitchell 1983. In sum, Congress's power to legislate with respect to Indians is well established and broad, but it is not unbounded. It is plenary within its sphere, but even a sizable sphere has borders. Syllabus Section 1B. Petitioners contend that ICWA impermissibly treads on the state's traditional authority over family law. But when Congress validly legislates pursuant to its Article I powers, the court has not hesitated to find conflicting state family law preempted, notwithstanding the limited application of federal law in the field of domestic relations generally. Ridgway v. Ridgway 1981. And the court has recognized Congress's power to displace the jurisdiction of state courts in adoption proceedings involving Indian children. Fisher v. District Court of 16th Judicial District of Montana, 1976, per curiam. Syllabus Section 1C. Petitioners contend that no source of congressional authority authorizes Congress to regulate custody proceedings for Indian children. They suggest that the Indian Commerce Clause, for example, authorizes Congress to legislate only with respect to Indian tribes as government entities, not Indians as individuals. But this court's holding more than a century ago that commerce with the Indian tribes means commerce with the individuals composing those tribes. United States v. Holiday 1865 renders that argument a dead end. Petitioners also assert that ICWA takes the commerce out of the Indian Commerce Clause because children are not commodities that can be traded. Brief for individual petitioners. This point, while rhetorically powerful, ignores the court's precedent interpreting the Indian Commerce Clause to encompass not only trade, but also other Indian affairs. Petitioners next argue that ICWA cannot be authorized by principles inherent in the Constitution's structure because those principles extend, at most, to matters of war and peace. Brief for petitioner Texas. Again, petitioners make no argument that takes this court's cases on their own terms. The court has referred generally to the powers necessarily inherent in any federal government and has offered non-military examples, such as creating departments of Indian affairs. Petitioners next observe that ICWA does not implement a federal treaty, but Congress did not purport to enact ICWA pursuant to its treaty power, and the Fifth Circuit did not uphold ICWA on that rationale. Finally, petitioners turn to criticizing this court's precedent as inconsistent with the Constitution's original meaning, but they neither ask the court to overrule the precedent they criticize nor try to reconcile their approach with it. If there are arguments that ICWA exceeds Congress's authority as precedent stands today, petitioners do not make them here. Syllabus Section 2. Petitioners' anti-commandeering challenges, which address three categories of ICWA provisions, are rejected. Syllabus Section 2A. First, petitioners challenge certain requirements that apply in involuntary proceedings to place a child in foster care or terminate parental rights, focusing on the requirement that an initiating party demonstrate active efforts to keep the Indian family together. Section 1912D. Petitioners contend this subsection directs state and local agencies to provide extensive services to the parents of Indian children, even though it is well established that the 10th Amendment bars Congress from commanding the state's officers, or those of their political subdivisions, to administer or enforce a federal regulatory program. Prince v. United States, 1997. To succeed, petitioners must show that Section 1912D harnesses a state's legislative or executive authority. But the provision applies to any party who initiates an involuntary proceeding, thus sweeping in private individuals and agencies as well as government entities. A demand that either public or private actors can satisfy is unlikely to require the use of sovereign power. Murphy v. National Collegiate Athletic Association, 2018. Petitioners nonetheless insist that states institute the vast majority of involuntary proceedings. But examples of private suits are not hard to find. And while petitioners treat active efforts as synonymous with government programs, state courts have applied the active efforts requirement in private suits too. That is consistent with ICWA's findings, which describe the role that both public and private actors played in the unjust separation of Indian children from their families and tribes. Section 1901. Given all this, it is implausible that Section 1912D is directed primarily, much less exclusively, at the states. Legislation that applies even-handedly to state and private actors does not typically implicate the 10th Amendment. Murphy, 2018. Petitioners would distinguish the court's precedents holding on the grounds that those cases addressed laws regulating a state's commercial activity, while ICWA regulates a state's core, sovereign function of protecting the health and safety of children within its borders. Brief for Petitioner Texas. This argument is presumably directed at situations in which only the state can rescue a child from neglectful parents. But the state is not necessarily the only option for rescue, and Section 1912D applies to other types of proceedings too. Petitioners do not distinguish between these varied situations, much less isolate a domain in which only the state can act. If there is a core of involuntary proceedings committed exclusively to the sovereign, Texas neither identifies its contours nor explains what Section 1912D requires of a state in that context. Petitioners have therefore failed to show that the active efforts requirement commands the states to deploy their executive or legislative power to implement federal Indian policy. And as for petitioners' challenges to other provisions of Section 1912, the notice requirement, expert witness requirement, and evidentiary standards, the court doubts that requirements placed on a state as litigant implicate the 10th Amendment. But regardless, these provisions, like Section 1912D, apply to both private and state actors, so they too pose no anti-commandeering problem. Syllabus Section 2B. Petitioners next challenge ICWA's placement preferences, set forth in Section 1915. Petitioners assert that this provision orders state agencies to perform a diligent search for placements that satisfy ICWA's hierarchy. Just as Congress cannot compel state officials to search databases to determine the lawfulness of gun sales, Prince 1997, petitioners argue, Congress cannot compel state officials to search for a federally preferred placement. As with Section 1912, petitioners have not shown that the diligent search requirement, which applies to both private and public parties, demands the use of state sovereign authority. Moreover, Section 1915 does not require anyone, much less the states, to search for alternative placements. Instead, the burden is on the tribe or other objecting party to produce a higher-ranked placement. Adoptive Couple v. Baby Girl 2013. So, as it stands, petitioners assert an anti-commandeering challenge to a provision that does not command state agencies to do anything. State courts are a different matter. ICWA indisputably requires them to apply the placement preferences in making custody determinations. Sections 1915 A-B. but Congress can require state courts, unlike state executives and legislatures, to enforce federal law. See New York v. United States 1992. Petitioners draw a distinction between requiring state courts to entertain federal causes of action and requiring them to apply federal law to state causes of action, but this argument runs counter to the Supremacy Clause. When Congress enacts a valid statute, state law is naturally preempted to the extent of any conflict with a federal statute. Crosby v. National Foreign Trade Council 2000. That a federal law modifies a state law cause of action does not limit its preemptive effect. See example given, Hillman v. Moretta, 2013 federal law establishing order of precedence for life insurance beneficiaries, preempted state law. Syllabus Section 2C. Finally, petitioners insist that Congress cannot force state courts to maintain or transmit records of custody proceedings involving Indian children. But the anti-commandeering doctrine applies distinctively to a state court's adjudicative responsibilities. Prince 1997. The Constitution allows Congress to require state judges to enforce federal prescriptions, insofar as those prescriptions relate to matters appropriate for the judicial power. In Prince, the court indicated that this principle may extend to tasks that are ancillary to a quintessentially adjudicative task, such as recording, registering, and certifying documents. Prince described numerous historical examples of Congress imposing record-keeping and reporting requirements on state courts. These early congressional enactments demonstrate that the Constitution does not prohibit the federal government from imposing adjudicative tasks on state courts. Bosher v. Sinar, 1986. The court now confirms what Prince suggested. Congress may impose ancillary record-keeping requirements related to state court proceedings without violating the 10th Amendment. Here, ICWA's record-keeping requirements are comparable to the historical examples. The duties ICWA imposes are ancillary to the state court's obligation to conduct child custody proceedings in compliance with ICWA. Prince 1997. Syllabus Section 3. The court does not reach the merits of petitioners' two additional claims, an equal protection challenge to ICWA's placement preferences and a non-delegation challenge to Section 1915C, the provision allowing tribes to alter the placement preferences, because no party before the court has standing to raise them. Syllabus Section 3A. The individual petitioners argue that ICWA's hierarchy of preferences injures them by placing them on unequal footing with Indian parents who seek to adopt or foster an Indian child. But the individual petitioners have not shown that this injury is likely to be redressed by judicial relief. TransUnion, LLC v. Ramirez 2021. They seek an injunction preventing the federal parties from enforcing ICWA and a declaratory judgment that the challenged provisions are unconstitutional. Yet enjoining the federal parties would not remedy the alleged injury, because state courts apply the placement preferences and state agencies carry out the court-ordered placements. Sections 19031, 1915 AB. The state officials who implement ICWA are not parties to the suit, and there is no reason they should be obliged to honor an incidental legal determination the suit produced. Lujan v. Defenders of Wildlife 1992, plurality opinion. Petitioners' request for a declaratory judgment suffers from the same flaw. The individual petitioners insist that state courts are likely to defer to a federal court's interpretation of federal law, thus giving rise to a substantial likelihood that a favorable judgment will redress their injury. But such a theory would mean redressability would be satisfied whenever a decision might persuade actors who are not before the court, contrary to Article 3's strict prohibition on issuing advisory opinions. Carney v. Adams 2020. It is a federal court's judgment, not its opinion, that remedies an injury. The individual petitioners can hope for nothing more than an opinion, so they cannot satisfy Article 3. Syllabus Section 3B. Texas has no equal protection rights of its own, South Carolina v. Katzenbach, 966, and it cannot assert equal protection claims on behalf of its citizens against the federal government, Alfred L. Snap and Son, Inc. v. Puerto Rico Eggs Rel Perez, 1982. The state's creative arguments for why it has standing despite these settled rules also fail. Texas's argument that ICWA requires it to break its promise to its citizens that it will be colorblind in child custody proceedings is not the kind of concrete and particularized invasion of a legally protected interest necessary to demonstrate an injury in fact. Lujan 1992. Texas also claims a direct pocketbook injury associated with the costs of keeping records, providing notice in involuntary proceedings, and producing expert testimony before moving a child to foster care or terminating parental rights. But these alleged costs are not fairly traceable to the placement preferences, which operate independently of the provisions Texas identifies. California v. Texas, 2021. Texas would continue to incur the complained of costs even if it were relieved of the duty to apply the placement preferences. Because Texas is not injured by the placement preferences, neither would it be injured by a tribal resolution that altered those preferences pursuant to Section 1915C. Texas, therefore, does not have standing to bring either its equal protection or its non-delegation claims. And although the individual petitioners joined Texas's non-delegation challenge to Section 1915C, they raise no independent arguments about why they would have standing to bring this claim. Affirmed in part, reversed in part, vacated and remanded in part. Barrett delivered the opinion of the court, in which Roberts and Sotomayor, Kagan, Gorsuch, Kavanaugh, and Jackson joined. Gorsuch filed a concurring opinion, in which Sotomayor and Jackson joined as to parts 1 and 3. Kavanaugh filed a concurring opinion. Thomas and Alito filed dissenting opinions.